Thank you very much for joining after lunch. I know it's always a challenge and there was no coffee, so apologies for that. So I used to be a member of the KU Leuven many years ago, so I'm very grateful to my colleagues that invited me to join you here. I'm now a professor at Tilburg University. I'm a professor of technology, law and human rights, and I'm here to tell you everything that Bart told you should ignore. So thank you, Bart, for making my life very difficult. The law is there, you're just ticking boxes, all these boring people. So yes, it's true, but you need to respect that, and actually you need to work with the legal people in your teams because you will get heavy fines. At least that's something that you can get, and that should motivate you, right? The work of the lawyers is, I would say, pretty challenging in these days because things are changing. I have not focused on cybersecurity, so I'm not talking about NIS2. I'm happy to talk to you afterwards or answer questions. I will say just a few things. Because I try to focus, and that's what Svetla invited me to talk about, is privacy and data protection. So when I started preparing this presentation, I ended up with about, I don't know, like 200 slides, and then I was like, cut down. It's only 1 hour. So please raise your hand and ask me if you want me to elaborate on something. What I try to do is I try to give you an overview. An overview, first of all, of why do we talk about data in the energy sector? Everybody focuses on the infrastructure. You're technical people. You don't care about personal data. You don't care about the individual, about the consumer. You're mainly interested about making the system work, improving security, etc., etc. But there are rules that you need to respect. So this is the outline of my presentation today after a short introduction with a bit of with some comments on privacy. Then I move more on data protection, which is trying to explain the interplay between data protection, so personal data, and energy, especially in the field of electricity, and what are some challenges, posing some questions and suggesting some answers. And Bart has given an excellent introduction to my presentation, so I will be referring back to him quite a bit. So if you look at the news, you will see a lot of news items. Is your smart meter spying on you? Should we switch off our smart meters? What are the governments doing? Why do we need to install these new meters? And here I come asking whether this is old wine in a new bottle, because we have been talking about smart meters and problems that relate to privacy and data protection for more than 10 years, when actually the European Commission started thinking of the new energy system. I think you're very young, most of you are very young, but some of us remember energy monopolies. We just had the man working for the electricity company knocking on the door saying, I want to check the meter so that I can send you the bill, and that was it. Nobody worried. Nobody worried about Ukraine and Russia and gas, and nobody had solar panels, nobody had meters or anything. So when this started changing, everybody got very worried. So what you see now in the news, you see already here in 2010, we had a very similar headline, smart meters, privacy warning over personal data, and similar, I would say, outcries from the Electronic Frontier Foundation in the United States about the smart meters and how dangerous they can be for our privacy. Who cared? Nobody. Then the European Commission said, no, this is what we want to do, and that's how we should move on. Meanwhile, a lot of people got jobs because they started designing the new systems, but also lawyers starting analyzing how we can implement systems that are more privacy-friendly, how we can collect less data, how can we protect the customers. So the energy sector, as I have it in mind for this presentation, is more or less this. So we have a generator of energy, it can be any type. We have a transmission system. The electricity is sent to the suppliers, and through the distribution system operators, the so-called DSOs, these are very important ones, they distribute the energy to every final customer. This can be companies, this can be factories, this can be smart homes through the smart meter. And this is more or less the model we have, and on top of that, we have the discussions about peer-to-peer sharing of energy. Can I borrow energy from my neighbor that has solar panels? If I can, how can this be done? Who gets paid for that? How can the system be properly established for that? So the system has become quite complicated. And this is a slide that I found very interesting and very clear when you can see the multitude actually of different devices that you have in this model of today, where we have sensors and you have different batteries and smart equipment and the smart self-consumption with solar panels and different types of meters, etc. You have different types of connection channel, so you can use Wi-Fi, you can use fiber, there are at some points public Wi-Fi, there are mobile data, and here comes Bart with his cybersecurity discussion. But something I want you to keep in mind when we talk about cybersecurity and NIS, so the Network and Information Security Directive, NIS 2 especially, what they focus on there is not the data, it is the infrastructure level. Mainly. And the novelty of NIS 2 was that, one of the novelties of NIS 2 is that they extended the, the scope of sectors that fall under NIS 2, including outer space, which I found extremely interesting because I'm doing some work now on the space debris. So that's not for you now, but there is much going on outside also in the space. So I tried to find a source, and this is a quite recent paper that has a classification of the types of data that can be relevant in the context of the energy sector. So we have data that relate to the network, the so-called network data. These can be structural data of assets or operational data. They can be forecasted and actual. We use AI, so a lot of the forecasting and prediction is very important in the field of energy in order to manage the grid better and distribute energy, etc., etc. Market data are very important for the companies. They have to do with bids and offers on wholesale markets for electricity and related products, prices, imbalance and settlement data, and then I go here, external data. They can be weather and climate data, socio-economic data, so all these are used, but here what you see as consumer data is what is the category that is more important for me during this presentation, not undermining the rest of the sets, of course. So consumer data are data that relate to the metering and consumption data, the output of distributed generation, billing data, customer data, so the data, the information about the customer themselves, and a lot of metadata. Why do I consider this the most relevant for us? Because these are what we call personal data. And in the next section, I'm going to present you with a definition of personal data. But I'm going to tell you already now that personal data are data that relate to an identified or an identifiable human being. So no companies. Companies are not interesting for the data protection regime. And this is what, for the electricity sector, coincides to the largest extent with what they call consumer data. The reasons why personal data are processed are manifold. First of all, there are a number of legal obligations. So there are a number of obligations that are established in a lot of European and national laws that oblige, let's say, distribution system operators to collect and process data for the management of the grid, or for the actual supplying of electricity, or in order to enable supplier switch. If I'm with a company and I want to change, they need to have quite a bit of information about me to facilitate the switch of the suppliers. Besides the legal obligations, the previous one can also be for billing, of course. If I need to be charged, they need to know what they charge me of. The processing for additional services or enhanced, D is missing there, systems, for example, to offer personalized offers or for the development of energy management systems that are not actually essential for the delivery of the electricity, but they're beneficial, they're an add-on, and there the question starts. And Bart said, well, what do? They get consent and then they can do everything. And here I come and say, maybe they do this, but they shouldn't. So I'll come back to that. How can we do this? And when can we do this? Of course, personal data is a field that is very sensitive because it's our personal information. A lot of information can lead to the creation of profile, but they also relate to issues relating to privacy. And I start for lawyers, like, what is she talking about? Privacy data protection is the same thing. Well, it's not exactly the same thing. It's quite similar, but it's not identical. So privacy is more broad. Privacy is about the protection of private life, family life, and we can classify the main, I would call, privacy concerns relating to the energy sector. And actually, when we talk about final consumers, they relate to the use of smart meters and the information we can get through the smart meters and the billing information. So it's the creation of a very detailed profile of household habits. If somebody has access to your detailed metering data, they can get quite a bit of information about you and the family habits. When are you at home, when you're away, when you're on holiday, what kind of devices you're using, and I will show you some screenshots from our own smart metering. Remote reading of meters. You are technical people, you know it much better than me. They create the opportunity for hacking, and they raise a lot of security concerns. There was a long debate back in the beginning of the previous decade about compulsory nature of smart meters rollout. So when the European Commission envisioned this new system in Europe, this new reality for Europe, they initially thought every household should have a smart meter, which means we make this compulsory. But there were a lot of reactions against that, saying that no, this should be an option. So what happens in reality, I don't know in many other countries. I know that in the Netherlands they had to modify the law and make it optional, but I will give you my personal experience. They more or less force you to that. So when there was Stedin in the Netherlands, so the provider, the infrastructure provider, they wanted to have the system installed in all households in our neighborhood to get a smart meter. I told my husband, no, I don't want a smart meter for this and this and this reason. So we didn't get the smart meter. So soon after we got the letter that the company is not providing maintenance to our old hardware equipment anymore, that we wouldn't be able to enjoy the low and high tariff anymore. And then, of course, you start having the practical issues. At some point, we wanted to have solar panels, but then you cannot have solar panels if you don't have a smart meter, which, of course, you get for free because this is a gift, because then you pay so much money afterwards. So then, after 4 years of refusing, then we did get our smart meter, I have to say, and I'm not happy about it at all. And there's a lot of lack of transparency. What's happened behind the scenes? What happens with our data? What kind of data do they get? Do they actually get, do the DSOs and our providers, do they get only aggregate data about our consumption? Is what I see on my app what they get as well? So I'm asking the difficult questions and I'm not getting always very clear answers. So I'm not a very big defendant of the system, especially in the way how this has been rolled out, especially in the Netherlands. So I hope you got an idea of the context, because that's what I wanted to show you in the first part, the context, which is the context in which we are going to have a discussion. Any questions? So now I'm going to go a little bit deeper into data protection and into the electricity fundamentals. So we have a lot of laws, and I will try not to tire you too much, but I think it is important that I show you also some provisions and then we discuss about their implementation in practice. So we start with the European Charter. What is the Charter? The Charter is the following. You know that almost all countries have a constitution, and in the constitution there is a list of fundamental rights. At European level, we did not have that. So every member state, every European member state had their own constitutions, and their courts were relying on their own regime for the protection of fundamental rights. Then at some point there were reactions against that, because a right was protected in one way in one member state and a different way in another member state. So there was an attempt to create the so-called Fundamental Rights Charter at EU level, which was finally adopted and adopted in 2000 and put into force almost 10 years later, together with the Lisbon Treaty. Okay, that's too legal, but just keep it that we have a list of fundamental rights at European level. That is unique because it has a specific article in Article 8 that protects personal data. And that is very special because there are not that many constitutions that have a separate right for the protection of personal data. What was happening in the past is the majority of the cases that dealt with personal data and the processing of personal data at the fundamental rights, at the constitutional level, was protected under the right to privacy. But as I told you, these are not exactly the same. So this is considered to be a success, a novelty of the Charter. So everyone has the right to the protection of the personal data concerning him or her. And the processing needs to be done in a fair way for specified purposes. This is what comes against what companies want to do. They want to collect data and use them for all purposes. No, they need to be for specified purposes. And here's the catch: on the basis of consent of the person concerned or some other legitimate basis. So we are going to spend some time on looking at the legitimate basis and what legitimate basis can you use in the field of electricity, in the sector of energy, when you process personal data. I call it still a new secondary legal framework, but it's not that new anymore. It's been already 4 years since the new legislation on the protection of personal data has entered into force. There are a number of pieces of legislation that it comprises of. The most important ones is the so-called GDPR. Is there anybody that hasn't heard about GDPR? Of course not. Nobody knew about the Data Protection Directive before that, and now everybody knows about the GDPR, especially because of the high fines, but not much has changed, I have to say. And then there is also another directive on the processing of personal data for law enforcement purposes. But we are focusing here on the first one, the General Data Protection Regulation. There we find the definition of personal data. Personal data are any information, as I said, relating to identified or identifiable natural person, with examples: name, email, shipping address, credit card number, individual purchase history, customization, attendance to events, etc., etc. Usually the problem I have when I work with computer scientists is that they want to create typologies. They want to have very clear classification of data. Is this personal data or is it not? And I say, it depends on the context. No, I hate you, I cannot put it in the system. What does it mean? It depends. So you always need to work together with the lawyers and really see what your system is doing and see whether a piece of information can potentially be linked with another piece of information that will allow you to identify somebody behind, an individual behind it, because that turns the piece of information into personal data, and then the GDPR is invoked. So to me, this is a very important lesson for you to remember. You don't have this clear list. If I give you a list of 200 pieces of data, and we try to do this exercise, is this personal, is this not personal, we will not be able to do it. We need to discuss there are some pieces of information that are very clear that they are personal data, but not everything. So please keep that in mind. Because then there can be data that by reference to an identifier that leads to the singling out, so then you can get to the identification element via cookies, IP addresses, key-coded or pseudonymized data, etc., that turn data into personal data. Then there is another term that you may hear quite often, and it's the term sensitive data. And sensitive data is not the data that you consider sensitive. There is a closed group of data that is specifically mentioned in the GDPR that are characterized as sensitive data. And why is it important to know which these data are? Is because their processing is in principle prohibited. And you can only process them under specific conditions that are outlined in the law. Is there a question? No. So sensitive data are medical and health-related data, data revealing racial or ethnic origin, political opinion, religious or philosophical beliefs, trade union membership, genetic and biometric data, criminal convictions, and offenses. And you may think, well, we don't have financial data there. We don't have location data there. It's true, there has been a lot of discussion whether such data should be included, but imagine if we say that these are also sensitive data and their processing is prohibited. I think most of the applications or the systems that you are developing wouldn't be able to work. So we try to have different regimes, different frameworks that have some safeguards next to them in order to protect those data, but not consider them as sensitive data as such. Another point to clarify is the difference between anonymous data and pseudonymous data. I mean, I don't need to explain this audience what's pseudonymous and what's anonymous, but when I teach it to legal scholars, that's quite a bit of a nightmare. Just keep in mind, truly anonymous data, let's not start debating when we have true anonymization. Truly anonymous data, they don't fall under the GDPR. They are not considered as personal data. However, pseudonymous data, they remain personal data, which means that if you run pseudonymization in your data set, they remain personal data, and you still need to comply with all the rules of the GDPR. And of course, aggregated data, they are data that do not refer to an individual, and then you don't need to process them anymore in accordance with the GDPR. So this is the first framework. This is the data protection framework. It's quite complex in itself, and Bart was not a big fan of it, as you understood in the morning. On top of that, we have the energy sector. And the energy sector is a big hype. Energy and health are attracting the majority of the money for research projects at the moment. So there is a list of legislative instruments. I will explain to you a little bit more in detail. And they are not that old, as you can see. So in 2015, the European Commission decided that we need a completely different framework for energy in Europe, which is called Clean Energy for All Europeans. So Clean Energy for All Europeans was the motto of the European Commission. 2015, we have a communication from the European Commission with the main aims and goals of the new system. And there were 8 legislative instruments that were adopted under the Clean Energy for All Europeans package. You see that some are regulations and some are directives. I'm not sure if everybody is familiar with the difference. Okay, so they are both legislative instruments. You can call them more or less European laws, although this is terrible, don't use it outside this room. There are 2 different types of these laws. So the regulations are the ones that are decided at the European Union level. So they are decided by they are proposed by the European Commission and then adopted by the Parliament and the Council. And their text is valid for all European member states. This is what you get. It's a regulation, you cannot get away with it. Maybe there are some small possibilities for small adaptations at national level, but the rules are there. Directive is very different because the directive is a harmonization tool. So the main principles and the main rules are in the text of the directive. However, every member state has to transpose it, to implement it at national level with a national law. And then they have quite a bit of margin when they do this transposition. So in the end, we see differences between the national laws that rely on the same directive. Is this clear? Okay. So regulation is, that's it, dudes. You can do nothing about it, and then you just have to respect it. Directives, the national governments and the national parliaments need to work on the adaptation of the directive into national law. So I don't want to tell you all these documents because in any case it would be extremely boring, but I have highlighted the importance of the electricity directive. And actually it is a recast. Recast means that we did have an old electricity directive, and then we see that the field has changed so much that we didn't just amend it, but we actually restructured it completely. But we keep the title because we want to show the continuity. So we have this so-called Electricity Directive of 2019 that was adopted after the GDPR. This is very important. And it wants to make sure that the personal data that are processed in the context of the electricity sector are protected, and this is done in line with the GDPR. So we are going to look into some provisions of the Electricity Directive in the coming slides. One important element in the Electricity Directive is the so-called data management, management of data. Recital 91, do you know what a recital is? No, good. So when we have these regulations and these directives, so the law, there is some text before it. It's like a preamble. It's like an explanatory text that does not have legal validity, but it helps us interpret the actual provisions of the law. And there are paragraphs that are called recitals, and they are like, every paragraph has a number so that you can refer to it. And this is recital 91 of the Electricity Directive that says, this directive respects the fundamental rights and observes the principles recognized in the Charter. By now you should know what the Charter is, right? In Article 8 we said protects protection of personal data. Accordingly, this directive should be interpreted and applied in accordance with those rights and principles, in particular the right to the protection of personal data guaranteed by Article 8 of the Charter. Yeah? So you see the link. It is essential that any processing of personal data under this directive comply with the GDPR. So that's why we spent a few slides discussing the data protection framework, because when we want to work with electricity and we process personal data, then we need to respect the GDPR as well. One of the novelties on how data management is done, especially when this is left to the hands of the consumers, is through smart meters, and the introduction, the actual rollout of smart meters is considered to be one of the novelties of the Electricity Directive. How many of you have smart meters at your house? Wow, who's expecting more? Good, resist. Impressive. If you ask this in the Netherlands, it's really, really high. So we have, you didn't get one? Well, we're forced, you know, I keep complaining. I mean, yeah, they create friction among couples. So I have not downloaded the app. At least that's my position. But I asked my husband to make some screenshots to show you today. So this is what the application of the smart metering app we have at home looks like, which I hated. Did I say that? So we have different tabs. This is the electricity tab. And they are detailed like crazy. Say, your largest consumer is standby devices. So they know what kind of devices we have and which of them are on standby. Then there's a split on, okay, these are the standby. This is white goods. Do I have 2 fridges? Do I have a freezer? Do I use often my washing machine or my dishwasher? Do I hate that? Kitchen equipment. Do I cook a lot? Do I not cook a lot? Lighting and entertainment. That's also something I have a follow-up. But you see how detailed this is, right? Like, my kids will hate me when they are teenagers, and then I check, oh, entertainment, that's too much. What have you been doing while I was at work? Well, so this is electricity. So this is lighting and entertainment. So you can click on each one of these, and then you get an aggregation. And another thing I hate is here. So you get this that says, for lighting and entertainment, you use so many kilowatt, and this is 36% more compared to other households. So then I go like, what's other households? We are with 4 and we have 2 babies. Like, they don't do anything. So other households are semi-detached house with 4. We don't really work from home that much. So I really wonder how we can be 36% and who makes this aggregation? What is this algorithm? Who has developed this algorithm? How do we test the algorithm? Where is the transparency? So this makes me very upset. So I don't download it, but still. Then you can easily see that in August we were on holiday, right? Like you don't need more data than that. Then in June we had visitors. So you can easily see that there is a lot of much more consumption, that may be something there. And if I would have time to go through all the screenshots, all the tabs, you would see that you can get such a detailed profile of the family that it is upsetting. I mean, to me, it is upsetting. And my biggest question is, what kind of data does my electricity provider, does the DSO get from this? What's on the app? Only the aggregates? So, yeah, this is where you come in. Make the best systems. Don't allow them to get all the data unless you work for them and then you get a very good salary to collect as much data as possible from us poor consumers. Anyways, so smart meters, as I said, they are a novelty of the electricity directive and was clearly mentioned. And this is from a report from the Joint Research Center in a report about electricity systems and interoperability, where they say that member states, in the context of this green energy for all Europeans, shall ensure the deployment in their territories of smart metering systems that assist the active participation of consumers in the electricity market. So first of all, I get the smart meter, I see a very detailed analysis of how I use my cooking plate and my fridge, and then I'm supposed to be an active member of the electricity market, and also they give us the possibility to have solar panels and actually feed back to the network. So this is all seen in a very positive way. Such deployment may be subject to a cost-benefit assessment, and there has been long debates. Who does this cost-benefit? Who should it be beneficial towards? What are the criteria? Who bears the financial burden, etc.? Where the deployment of smart metering systems has been negatively assessed as a result of the cost-benefit assessment, every final customer is entitled on request to have a smart meter installed to be able to check it, because somehow we really need to convince you that that's what you need to do. The goal is, at European level, that by 2030, 266 million smart meters are expected to be installed, covering 92% of the European consumers, which will represent a total aggregated investment of 46 billion euros. And definitely this group in here is not representative of reaching the 92% goal. But I can assure you, depending on the national policies, they can really push for it. And I see it living in the Netherlands, how much power these companies can get when they have the support of the government. Then, of course, you get into debates that go a little bit beyond data protection, but I would like to raise your awareness. Okay, we want customers to participate in the electricity market. We want them to install solar panels so that they can contribute, that we don't overburden the grid, that we become more independent from external sources, like what Bart was describing this morning with war in Russia, etc., etc. But then you see that laws are changing all the time. And then as soon as you get the consumers invest, then the rules for buying back this, the energy that they are consuming change. There are situations when consumers are asked to shut down their system because the energy they are consuming cannot be absorbed, etc. So this is a very complicated thing. Then I move to Article 23 of the Electricity Directive, which is about data management. So following up, building on the recital 91 that I already showed you. Member states shall organize the management of data in order to ensure efficient and secure data access and exchange, as well as data protection and data security. So here, what was in the recital, you see it as part of the directive itself. It cannot be that a member state decides to disregard protection of personal data just because they want it. It is there. How do you do it in detail? That's something that is not stipulated there. So you need to get experts to explain to the companies how to do the data accessing, the exchange, how to make sure that they ensure protection of personal data, how can they deliver the best security for the data. It's all very complicated. We've been doing this for years. We will continue doing this. So these very nice statements do not really mean something. That's what I want us to discuss in the next section of my presentation. The rules on access to data and data storage for the purpose of this directive shall comply with the relevant union law, and the processing of personal data within the framework of this directive shall be carried out in accordance with the GDPR. Did we hear it many times? Yes. Do we know what we need to do? No. Let's move on. Article 34 is interesting because it does not talk only about personal data, but it brings in another element that I consider extremely important. It's the element of non-discrimination. And non-discrimination is another fundamental right. Member states shall ensure that all eligible parties have non-discriminatory access to data under clear and equal terms. Clear and equal terms. We need to be transparent. We need to have good rules. Everybody should have access to the infrastructure, and the data should be processed in such a way that do not lead to discrimination. In member states where smart metering systems have been deployed and where distribution system operators are involved in data management, the compliance program shall include specific measures in order to exclude discriminatory access to data from eligible parties. In simple words, what happens if we don't have enough electricity? Who gets access to electricity? Whom do you cut out of the system? Do you prioritize the big factories and leave the households without electricity? Do you do it vice versa? How do you feed more energy in the system in order to cover the needs? How do you have a grid that has such capacity to meet all the needs of all parties that are linked to this grid? And if this capacity is not enough, what happens so that how do you prioritize in order not to lead to non-discrimination? Of course, there are more powerful actors and there are less powerful actors. That's what they want to avoid, but I'm not sure at this moment that it will be a very easy decision to shut down some factories in order to allow some poor income neighborhoods to have electricity if there is a serious problem. So this is where some more fundamental rights issues arise. And the report of the JRC that I already referred to also highlights the importance of interoperability of energy services. And there is a recommendation to the European Commission that it shall adopt interoperability requirements and non-discriminatory and transparent procedures for access to data. So what the JRC says is that we shouldn't leave it up to the member states, we shouldn't leave it up to the sector, we should have guidance from the European Commission in order to make sure that there is respect of fundamental rights and how should I call it, the lower income, because that's what it is about. Usually the lower income consumers do not get discriminated against. Any questions? Okay, it's after lunch also. Some challenges. I already told you that the data protection framework is in itself quite complex. There are 6 data protection principles that need to be respected when personal data are processed. Fairness, lawfulness, and transparency. I already talked about transparency. How transparent shall we be when we draft rules, when we draft policies, as DSOs, as providers, in order to explain our consumers exactly what kind of data are processed, how are they processed, for which purposes are they processed, etc., etc. Purpose limitation principle, storage limitation, accuracy, data minimization, security, integrity, and confidentiality. And I have a few slides about those because I consider them extremely important, because these usually give engineers, computer scientists, and everybody that is trying to develop and run a system that deals with personal data trouble. according to the so-called purpose limitation principle, data need to be collected for specified, explicit and legitimate purposes and can only be processed for such purposes or for purposes that are compatible with the initial ones. Which means that what Bart said this morning, that companies want to collect data and then they use them for all sorts of purposes, is something that they do, but they shouldn't be doing. And we see more and more fines by data protection authorities, by the supervisory authorities, saying exactly this. You have the data, yes, but you cannot use it for every other purpose that you find interesting or beneficial, or financially usually beneficial for your own company. Data minimization is another headache, really a headache. According to the data minimization principle, data can only be collected and processed when they are accurate, relevant, and limited to what is necessary in relation to the purposes for which they have been collected. Which means, especially when you deal with AI, when you deal with development of algorithms, where you want to get as much data as possible in order to train your algorithm the best possible way, you violate the data minimization principle per se. Because the rule is as little data as possible in order to achieve your goal. How do you do your assessment? Get the lawyers and the engineers, sit around the table and the fighting starts. No, you don't need this piece of data. Of course I need it. My functionality will not be there if I don't have this. Then you need to negotiate, and you really need to have a document where you outline and you explain why you need this data. And this made sense because this is a rule that originates from the 90s. So the Data Protection Directive entered into force, so the predecessor of the GDPR, in 1995 and was proposed in 1990. And this is a provision from that time. Get a new system and try to map out all different pieces of data that are collected and processed, map them to the purposes, and make sure that you comply with the data minimization principle. Good luck. Another, I think, very difficult to comply with principle is the so-called storage limitation. According to this, data shall be kept in a way that allows for the identification of the individual only for a period that is necessary for the purpose, which means you always need to go back to your data set and check. Do I still need this data? Was this purpose completed? Then I need to delete the data, because if I don't, I'm violating the storage limitation principle and I can get fined. So imagine the system that I showed you in the beginning in the electricity sector with all the data. How many actors we have, each one of them processes the data separately for their own purposes. They need to do their own mapping. They need to do their own linking to the purposes and the storage limitation. And of course, it's much more complicated, but I didn't to be as gloomy as I can. So it is not an easy task if you want to make sure that you fully comply with the data protection legislation. And that's only the principles part. Another very important, and I would consider it even more important element, is the so-called legal basis. What is the legal basis? The legal basis is a rule, it's a fundamental rule of data protection that says you cannot just process data because you like it. You cannot process data because you find it on the internet. You cannot process data because you want to develop something that you find interesting. You need to have a legal basis. You need to have a legitimate ground. You can only process personal data based on one of these 6 grounds. Either on consent, and I can tell you beforehand, consent is not the holy grail. Performance of a contract, we will see it's a very strict provision, so you cannot say, oh, I have a contract and then I can collect all sorts of data that I find interesting. So I'm an electricity provider, I sign a contract with my consumer and then I collect all the data and I claim I do this because I want to provide you with electricity. Compliance with a legal obligation, that's quite clear and that's nice if you can rely on that. Vital interest of the data subject, not easy to use in this context. Public interest, we will see an example. And legitimate interest, this is where the electricity sector will be heading towards, but it's very difficult if you want to do it properly to rely on this legal basis. So when we when we have this in the law, we get a lot of questions from electricity providers, network operators, DSOs, whatever, like the following. When can we rely on consumer consent? Or when is processing necessary for the performance of a contract? Or when can we process personal data in the public interest? Or when can we rely on legitimate interest? Can we just pick and choose? Give me some answers. First, let's look into the question, when can network operators or DSOs rely on customer consent? What is consent? Consent is any indication of the wishes of the data subject, and it has to be freely given, specific, informed, and there are a number of, I would say, requirements that are now introduced in the GDPR for the consent to be valid. So there needs to be no imbalance of power under free. So you cannot use consent in the context of employment sector. University, I'm an employee of the university. University cannot ask my consent to process my personal data because there is imbalance of power. I will not say no because I'm afraid of losing my job. It should be unbundled. There should be no linking between you need to consent to the processing of personal data in order for you to enjoy another service. That's something that used to happen a lot, and the GDPR wants to change it. And you need to be able to withdraw consent in a very easy way. Do I give consent in an electronic way? I need to be able to withdraw consent in an electronic way. And of course, I think it's a bad idea for companies to rely on consent, because the moment consent is withdrawn, you need to make sure that you remove the relevant data from all data sets that you have used it, and good luck with that. It needs to be a clear indication of the wishes of the data subject. So it needs to be distinguishable from other matters. What was happening in the past, there were contracts with small letters, and you were agreeing to a service, and then you were also agreeing to the processing of your personal data for advertising, blah, blah, blah. That's not valid anymore. These clauses are not valid. And it should be unambiguous. I hate this word. Like, how can you give ambiguous consent? Anyways, they consider it smart. We are complaining for more than 15 years that unambiguous should not be there. It's still there. So they consider it an affirmative action. You can click on a box, swipe something, sign if it is offline, and you cannot rely on pre-ticked boxes, because then the consumer is not actively doing something. It should be specific and informed. There should be a granularity in the purposes. You need to be very clear about the purposes. They need to be provided. The information needs to be provided in a clear way that can be understood by the layperson. And you need to be transparent. So yes, of course, then you get huge privacy policies. Who reads privacy policies? I don't read it either. It doesn't make sense, but then we are not informed, then that means that you can argue back that your consent is not valid. So consent is not really a good idea, but you can use consent, for example, if you are an electricity provider, when you want to provide personalized offers. Or for instance, when you want to provide your customers with some energy advice. That's an add-on. Then they really can choose if they want it or not. And in that case, you can rely on consent. Next question is, when is processing necessary for the performance of a contract, for example? Network providers say, well, we have a contract with our consumers. When can we rely on this contract in order to process personal data? And then we solve the issue of legal basis. What is the rule about relying on contract? According to the GDPR, processing needs to be necessary for the performance of a contract to which the data subject is party, or in order to take steps at the request of the data subject prior to entering into a contract. So what is important is that you need to prove as a provider that the data are absolutely necessary for the execution of the contract, not good to have, absolutely necessary to have. So that does not cover too many categories of data. An example of processing personal data based on contract can be the creation of the bill. So for billing purposes, we have a contract, I'm a provider, you're a consumer, I need to charge you for what you are enjoying based on the contract. For billing purposes, I provide a very detailed bill, and then you can check the validity of the amount that you need to pay. And in that respect, you can rely on contract. Another question is, when can we process personal data in the public interest? Well, this is the energy sector. It used to be a state monopoly. It is for the good of the society. It is for the good of, of our state. So public interest is very vague. We can argue what is public interest, as I told you, this could be an explanation. You can use, for example, an argument for public interest for the monitoring of the performance of the physical network. Does the network work? Do we have accidents? Do we need to repair? Even if there are personal data of your customers there involved, then you can process them in order to make sure that you fix the network and the system does not collapse. And potentially for the reduction of the global electricity consumption, if you don't have enough energy, you can also process information in the system in order to see whether you can have recommendations when some parts of the network can be less heavily loaded specific times of the day so that the network can keep working. So these are some of the examples when you can rely on a specific legal basis in the energy sector, which is why when we get questions, which legal basis shall I use in the electricity sector when I want to process personal data, then again, as a nice lawyer, I say it depends. So you need to give me the context, you need to give me the data, you need to give me the purposes, you need to give me the whole context, and then I make a report and an analysis, and you see in one case it can be consent, in another one be the contract, public interest, and you see that in a very smart way, I did not talk about legitimate interest because legitimate interest needs to balance the rights and they call it the rights and freedoms of the consumer versus the legitimate rights of the energy provider. So that really needs to be on an ad hoc basis, and it will be quite difficult in this context to prove that there is a reason for the energy provider to process personal data for their own legitimate interests. Moving towards the end, there are some provisions, some rules in the GDPR that I think you need to be aware of if you are not aware already. First of all, the security of processing. This is really a recommendation, a rule, a requirement that is addressed to the engineers, to the administrators of the systems. It's not going to be tested by the lawyers. Taking into account the state of the art, the cost of implementation, and the nature, scope, context, and purposes of processing, as well as the risk of varying likelihood and severity for the rights and freedoms of natural persons, the controller and the processor shall implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk, including inter alia as appropriate. So they recommend pseudonymization, encryption of personal data. You heard quite a bit this morning about it. The ability to ensure the ongoing confidentiality, integrity, availability, resilience, blah, blah, blah. So these are all things. What can we do to keep the system secure? This is a rule, but then it's not the lawyers that will say how this is done. This is again something that is given to the technical departments. They find out how the processing of the data can take place in a way that is secure. Again, here I remind you the discussion about anonymization and pseudonymization. So you see for the security, they don't talk about anonymization because we really need to keep access to the personal nature of the data. So we talk about pseudonymization, encryption. Don't throw away the key part. We usually need it back. There is a definition of pseudonymization in the GDPR. Is it good? Is it bad? Let's start fighting against, but at least they tried to come up with a definition of pseudonymization that reads as follows. It is the processing of personal data in such a way that the personal data can no longer be attributed to a specific data subject, so a specific individual, without the use of additional information. And this additional information needs to be kept separately and subject to technical and organizational measures to ensure that the personal data are not attributed to an identified or identifiable natural person, but if I can link it back, then I can still get back to the right natural person. So we want strong encryption, we want strong pseudonymization techniques. This is, again, where we all need to work together, because in the energy sector, there is this strive to collect as much data as possible. There is some work already done. I'm not the best to present you, but I just wanted to show you. And then there is the claim in the GDPR that we cannot only set up a system and afterwards do an assessment whether this complies with the GDPR or not. The main argument that the GDPR wants to put forward is that we need to get people with different backgrounds work together from the outset in order to make sure that privacy and data protection are established in the system from the outset. So from the design phase and by default. So the default should be, can I be privacy friendly and privacy unfriendly? Is it cheaper to be privacy unfriendly or whatever? No, we don't promote that solution. We need to be, to take into account the privacy and data protection rules and requirements from the outset and by design. So these are the rules that are already established in the GDPR about data protection by design and by default. It's something that we have been arguing for already before the GDPR. We have it now there, but not much has changed because companies just want to do their thing and they have the power. So on this happy note, I would like to thank you very much for your attention, and I'm happy to get any questions.